In the meantime, let's shift now to a blast from the past. Oregon's non-unanimous jury law, which we should note is now extinct. But for decades, under this law, a person in Oregon could get convicted of most crimes via a split jury. In other words, instead of needing 12 out of 12 jurors to get on board for a guilty verdict, lawmakers lowered the bar to 10 out of 12. And for years, we were the only state in the country where that was still allowed. That is, until last year, when the U.S. Supreme Court ruled that law unconstitutional. The thing is, the reason that we're talking about this tonight is that the mess created by, again, that now extinct law still lingers because there are a lot of people still in prison who were put there by split juries. And this has become something of a legal mess because of things like problem number one. We don't know who a lot of these people are. I'll let Lewis and Clark law professor Eliza Kaplan explain.
For more than the 85 years that we had non-unanimous juries here in Oregon, we had no mechanism to count them or to ensure that we even knew if people had non-unanimous juries. The only way we know if people had non-unanimous juries over the years is if their lawyer or if for some reason the judge asked for the jury to be polled and then put it on the record or wrote it on the verdict sheet. And so there are tons of people likely that were imprisoned in Oregon that had a non-unanimous jury and they didn't even know.
Okay. So what about people then who do have proof and do know that they were convicted by a non-unanimous jury? Well, there is another issue in those cases because if someone is still going through the appeals process, they can then show proof of a split jury verdict and they can get a new trial. A group called the Ramos Project says there are 427 cases in Oregon where that's already happened or where it's in the process of happening. But the thing is, if a person has exhausted all of their appeals, they cannot get a new trial just with proof of a non-unanimous conviction. The Ramos Project says there are at least 244 cases in Oregon like that, where basically people are stuck in limbo. So they are trying to get Oregon lawmakers to change that. In fact, during a hearing yesterday, they proposed a bill that would let people who fall into this category get a new trial. This is as long as they file their claim within 1 year of if and when this legislation gets passed. So they'd have to do it soon. However, the Oregon District Attorneys Association also testified at this hearing about how difficult it would be to retry all of these old cases.
Sometimes people have moved when we're trying to find our witnesses, they've moved, officers have retired, we're trying to find them, they live out of state, people's memories have faded. So, sometimes we can refresh their memories. Sometimes, they don't really recall, exactly because they've sort of put this behind them. And victims are, sometimes and oftentimes seriously traumatized by the process, especially in these child sex abuse cases or sexual assault cases.
Now, we do want to note again, there isn't any actual legislation yet. There was just a proposal. You saw that bill. And the state legislature doesn't actually formally meet to start voting on bills until February. So we'll absolutely keep you posted on where this debate goes next.
A lot of critics say Oregon's non-unanimous jury law was a holdover from Jim Crow-era racism. So how did we get here? Well, we've got to go all the way back to 1933 when a Jewish man named Jacob Silverman faced murder charges in Oregon. 11 jurors were ready to convict, but one wasn't. So as a kind of compromise, they convicted Silverman of manslaughter instead of murder, and he was sentenced to 3 years in prison. A lot of people thought his sentence was too light, including the editorial board of the Morning Oregonian. In November 1933, they published a, frankly, racist editorial. They wrote, "This newspaper's opinion is that the increased urbanization of American life and the vast immigration into America from Southern and Eastern Europe of people untrained in the jury system have combined to make the jury of 12 increasingly unwieldy and unsatisfactory." Oregon lawmakers heard the outrage, and a special election was held a year later in 1934. Voters approved a change in the Constitution, making it so only 10 of 12 were needed to convict somebody, except in cases of first-degree murder. That charge still needed to be unanimous. Supporters framed this change as a way of reducing congestion in the courts and saving tax dollars. Fast forward to 2020, and the U.S. Supreme Court ruled non-unanimous jury convictions unconstitutional. It's worth noting, at the time, Oregon was the only state in the country where these convictions were still allowed. And that's how we got here.